But you know, I'm just wondering, because now that you mentioned this case, I remember the Anambra matter. So it means that what we should have done at that time was look at those cases and see what could we have corrected.
Yes.
Because maybe if we had, we may not even have had what we had in Kogi, for instance.
I agree. I agree. That has always been the problem. Anambra's case was pathetic in the sense that at the end of the day, the Supreme Court held that he was never in the office. He never held office. He was never governor of the state. Now, what happened to third-party rights that he has created? What happened to money he had spent? What happened to the resources? What happened to money is also being paid? Is he going to reform? Now, these are some of my own concerns.
What about laws?
Well, what about laws
that he signed?
That he signed into
because the people there will say, look, I can't say he's not the one who tied these roads.
So these are some of the issues. And I think the time, and if we start doing this, it will discourage a lot of incumbents on going on that track. If we do this, it will discourage a lot of governors or a lot of office holders taking this route of litigation, because it's almost like ad infinitum. It continues in perpetuity until when the court finally now determines. So because look at this now. You've been sworn in, you're holding office, and then in the course of time, the court now kicks you out. You have spent plus or minus, let's say 2 years, fighting for a cause that is not going anywhere. And then at the end of the day, you're kicked out. Now the next man now comes in, he's sworn in, he's going to start his own tenure, he's going to start his own term, he's going to deploy his own resources. And now we're crying now that the states are poor. Look at all the expenses, look at all that's gone on.
That means we have to go back to looking at the Constitution. Constitutional review is very imperative here. If you look at the way you just highlighted the points and the problems that we have seen over the years in so many of these states. And sometimes we also have pending cases and we move ahead, maybe forward. For instance, what happened in Kogi State. We saw the bickering within the party. For instance, the APC, someone saying, I've written to say I won't go for this particular election, and nothing was done about that. He was also deemed to have been, fielded by his own party, and is still kicking at this point in time, even though we're moving towards the swearing-in of the governor-elect. All of this in our judicial system and our constitutional, matters calls for a review in the Constitution.
Certainly, there's no doubt about it. The one of Kogi State, quite frankly, it's unfortunate. I am one of those who believes that the step taken by the political party should not have been taken in the first place. It is also standing the law on its head. It's creating some sort of legal or constitutional crisis in the state as well. If you had a deputy who contested the election with a gubernatorial candidate who in the course of the election, mind you, the election had been conducted in part, and in the course of that, the gubernatorial candidate died. Naturally, if you look at the provision of, I think, Section 187 of the Constitution, which says that you cannot emerge to contest the election of governorship if you do not have a deputy. Now, what is the essence of deputy? You take the normal day-to-day conduct or life. You have a car, right? Your car will have a spare tire. Now, if you have a flat, what do? You don't seek tire from someone else because it's part of your car. So what do? You change the spare, and then the spare now becomes the tire to use with the car. Now, what APC has done in Kogi State is to go outside of the car to get a spare tire. And now the spare tire that should have moved to the main car has remained as spare tire. That for me is
not like the deputies are spare tires.
Yes,
but just
no. But that's what the Supreme Court said. The Supreme Court said deputies or the vice president, for instance, he holds forth for the president in the event of any crisis or eventuality. The vice or the deputy steps in.
But are you also looking at the other matters that's been thrown up now? Because the deputy is supposed to be a House of Rep member from Lagos, and then he's also standing elections in Kogi State.
Now, is he from Kogi State? Is he qualified to contest? Was he nominated? Was he appointed? Because you remember what I said. Section 187 says If I have to contest the governorship of my state, for instance, I'm empowered to pick a deputy to contest the election with me. Right?
So you can pick your deputy from anywhere?
Insofar as the deputy is from the state.
Well, the question now is, if you can pick your deputy from anywhere, can the deputy then rightfully stand in as governor when his, for instance, his polling unit is not in Kogi State?
No, you see, first and foremost, the thing basically what I think should happen is this. How come at the time he was fielded as deputy gubernatorial candidate, this issue didn't come up? Why is it coming up now?
Does it matter when it comes up?
No, it matters. What this will do, if the other political party, I hope the APC leaders in the state are also conscious of the fact that this can snowball into something that they cannot handle. Now you had a PDP governor who has lost the election. If he decides to challenge the election in the event that he decides to go to the election tribunal, I think there's a particular section of the Electoral Act, I think section 141, if I'm not mistaken, either 141 or 142, which talks about that if you have to approach the election petition tribunal, you must show evidence that you participated in the different stages of the election. The question you then ask yourself is, the man fielded, did he participate in the different stages of the election? The answer is no. So that creates another problem itself.
So it's a peculiar problem, really.
It is. There's no doubt about it.
In Kogi State. I was asking if you were worried about cases approaching the Supreme Court, if people are not satisfied with rulings from the appeal court and also imputing certain motives, perhaps, into, those. Does it raise a sort of concern for you in terms of faith in the judiciary?
It does. It does. It does in the sense that in the past, election cases in relation to governorship terminated at the Court of Appeal. They didn't go beyond the Court of Appeal.
That did longer time to deal with
cases. After the election petition tribunal determines the matter, your right of appeal will take you only to the Court of Appeal, and that ends it. This amendment to the Supreme Court came as a result of the election petition trial in relation to Sokoto under the erstwhile president. And there were a number of things. Now the constitution has been amended. What this now does is it gives an incumbent time to sit in office, access to resources of the state. Now, if at the end of the day the Supreme Court now reverses whatever the judgment had been, either, let's say, against him, and the Supreme Court now confirms, what then now happens to all that he has done? For me, yes, it might raise concerns about confidence in the judiciary. But I'm happy that, well, some of the cases, to a large extent, will confirm the integrity of the court and the sanctity of our judicial system, and to a large extent, give confidence to judicial stakeholders. But by and large, I believe we should go back to the old order of ensuring that once the election petition tribunal determines governorship cases and it gets to Court of Appeal, that should be the final.
Some of the contentious issues that have come up include the card reader. Do you think that should be scrapped?
I don't think so. It has worked well for us. We need to move forward. We need to strengthen the electoral process, and that is what I believe we need to do. I don't think we should do away with the card reader. It has helped to a large extent. You notice the aspect of electoral malpractices to a large extent has been reduced drastically.
But it cannot be used in the court of law.
No, what can be used are the ballot papers.
Because the card reader is not the Electoral Act.
Exactly. The Electoral Act merely recognizes the role that the polling officer is expected to play. Now, if I go with my PVC, right, it's inserted, he reads it. Yeah. And in addition to that, the electoral officer is also expected to look at the list of registered voters to confirm that in addition to elect the card reader, my name is also included on the list of registered voters.
And you know the argument that some have also raised, that amounts to electronic voting.
No, certainly not. Electronic voting, you and I know the way it is in developed societies. I can sit in Lagos, for instance, and cast my vote. That's electronic voting. That is not electronic voting. It's a process. It's not an end in itself. It's just a process. Now, without the card reader, it can also be done manually. So what we have done is we have used electronics to aid the process, but it's not It's not electoral. It's not electronic voting. It's certainly not.
But many who have argued about the challenge that the candidate poses suggest that maybe we should just fully implement electronic voting and let it be recognized by our laws.
Yes, if we have to. Before that can happen, the Electoral Act has to be amended. The Constitution has to be amended to accommodate it. I agree. But right now, what we're doing is not electronic voting. It's far from it.
When the former, okay, I know we got to wrap up, but when the, I think former CGN spoke about judicial reforms, the current one speaking about judicial reforms, it's becoming a trend, talking about it, but are they actually doing anything about it?
They are. Funny enough, just today, I was studying the independent corrupt practices and other related offenses law. Are you aware that there's a provision there that empowers any Nigerian who stumbles, for instance, on facts that project either the president or the vice president, the governor or the deputy governor as being corrupt, that there's a process, and the complaint is actually to be done to the office of the Chief Justice of Nigeria, who now set up a committee or appoint an independent legal counsel to investigate the matter. It's there. So it's also part of the process. We have the laws. The challenge we have now is just the will to implement this. The laws are there.
What about access to justice by the average person?
It's open. Now,
but
in
Lagos,
Lagos,
it's tougher.
It's not. In Lagos, for instance, you have the Office of the Public Defender, right? Now, you also have civil rights groups that are ready to take up cases. So access to justice is not fettered. You have right of access to justice.
Are there any SANs working in the Office of the Public Defender?
Not necessarily, but let me tell you what we do. We're all enjoined or legally required to do pro bono cases. I have a lot of pro bono cases that I do as well. It's part of what we're expected to do.
Because every year, or there's a time limit?
No, every year. You're expected to do that. You can't walk into if I see the injustice, it's not all the time that we take up cases that are of financial benefit to us. We're enjoined and encouraged to also do pro bono cases. And we do quite a lot of these cases.
But are there groups that really sit down, and if not, who should they be, to look at the cases that have been delivered, like the ones you spoke about, come up with those suggestions with a view to ensuring that, look, justice delivery, people see justice to have been done?
Yes, there are a number of committees that are in place. There's also the National Law Reform Commission, and there are a number of other agencies of government, including the National Assembly. If you have...
How come they didn't see the scenario in Kogi?
Someone has to kickstart the process. It's not for them. Someone has to kickstart the process. Just like complaint. The police will not investigate a crime if there's no complainant.
No, I'm talking about looking ahead to say, look, okay, nothing actually says if a candidate, after having done election in part, dies. What happens?
No, you see, in that, I've spoken on this a couple of times. You have to have what's called community reading of relevant sections of the Electoral Act, including the Constitution, in order to determine what should happen in relation to where the gubernatorial candidate dies in the course of the election. But there are other provisions in the Act in relation to that, but not a situation like this. So when you now have a situation like this, what you then now need to do, have community reading, and then subsequently amend the law to address this. You can't have a law that covers all scenarios, but anytime a particular scenario happens, as you progress, as you advance, you now need to enact a law in order to address that issue.
All right, thank you very much indeed. Mr. Norison Quakers is a senior advocate of Nigeria. We'll be back in just a moment. Don't go away.